Assalamualaikum and good morning, Ya Arif. I seek permission for the court to introduce myself. My name is Nurul Irdina binti Shahrani for Madihah Partners, and I appear before the court today acting on the behalf of the plaintiff, which is National Company for Foreign Trade. So in this case, I am as the lead counsel will be addressing on the salient fact of the case. Meanwhile, together representing me today is my other two co-counsel, Ms. Nur Anis Nadhira and Siti Madihah, will address on the ground of the application. Meanwhile, my friend and counsel, Ms. Aina Azmeeza, Ms. Hayatul Husna, and Ms. Syafawatul Husna appears for defendant from Syafa Associates representing the defendant. So on today's hearing dated 8 July 2023, the plaintiff in the case humbly asked for the High Court to grant the effective order 14 application for summary judgment as pleaded and submitted. May it please this honorable court, this is the plaintiff submission dated on 8 July 2023 to enter a summary judgment application against the defendant under Order 14.1 of the Rules of Court 2012. So if please the court, the plaintiff would like to put forward several points of contention for the consideration of this honorable court. So the plaintiff would like to support this application based on the three reasons, beginning with the plaintiff has a reasonable cause of action. Second, the defendant has no meritorious defense. And thirdly, the defendant has no tribal issues to be tried. Moving forward, Your Honour, if the court does not have any further inquiries, I humbly request to proceed with the brief fact of the case. Much obliged. So I would like to briefly explain this honourable court on the salient fact of the case. So firstly, the plaintiff is a Yemen International Trading Company, with its nature of business is providing high quality wood from a local distributor or retailer in Malaysia for resale in the Middle East. So at the time of the event, the defendant, KAYU RAYA, is a private limited liability company incorporated in Malaysia. So after negotiating with the defendant on 20 February of 1983, the plaintiff had entered into a contract with the defendant agreeing to supply of saw timber to the plaintiff. The plaintiff and the defendant had both agreed on the terms of the contract named KR/NCFT/14/79 dated on 16 March of 1983 in regard to the purchase order made by the plaintiff for the defendant to supply 19,392 tons of Kerawu sawn timber to the plaintiff, which is in the contract had stated the sawn timber will be shipped from various ports in Malaysia to Aden by the defendant for the months of April to December in 1983. And the term of payment was also stated in the contract, which the term of payment was $232 per ton. So because of the defendant has started to ship 6,049 tons of sawn timber in July 1983, the plaintiff had made payment amounted to $1,400,268 to the defendant as per agreed in the contract. However, the vessel carrying the sawn timber was arrested in Singapore during the journey and the said cargo of sawn timber was unloaded at Singapore. So be that as it may, Your Honour, according to the agreed minutes of 8 October, the defendant insists on taking full responsibility for reshipping all 6,049 tons of sawn timber for Singapore to Aden by another vessel and admits to being liable for the freight charge as well as incidental expenses arising from the cargo being unloaded and stored in Singapore awaiting the shipment to Aden, as stated in the contract cost and freight with the C&F clause. Thus, the defendant was borne with a charge amounting to 907,350 Singapore dollar for the shipment of the sawn timber. However, the plaintiff advanced the freight charges of 907,350 Singapore dollar at the request of the defendant in the agreed minute with an express undertaking that on or before December 31st, 1979, the defendant would compensate the plaintiff for the aforesaid sum less of 60,405 Singapore dollar that the plaintiff had agreed to bear. So despite the fact that the defendant had agreed to the contract, the defendant had taken no action to make full payment to the plaintiff in the amount of 800,046,930 Singapore dollar. So hence, the outstanding advancement sum due indicate there is a breach of agreement in C&F clause due to the non-payment of the balance sum agreed by the defendant. So the plaintiff, through its solicitor, Madihah Partners, had issued 3 letters of demand dated on 9 February, subsequently again on 23rd March, and again lastly on 14 July, all in 1983, to the said defendant claiming the outstanding sums, but the defendant had refused and ignored to obey the request or demand as specified in the notice. So I would like to direct the court attention. The defendant KAYU RAYA is at the commencement of the action justly and truly indebted to the above mentioned plaintiff in the sum of 100,046,930 of Singapore dollar for the particulars of the said claim appear by the endorsement of the writ in this action. So it is in the opponent belief that the defendant has no tribal issue due to the defendant unmeritorious defences and they are not issued to be tried as its main ground for the application. With that, Your Honour, that's all for the federal case. Continue to my counsel. We explain on the application. Thank you, Your Honour.
Bismillah, may it please the court. I, as the co-counsel, will be submitting the first and second issue, and my other co-counsel will be submitting the subsequent issue. Your Honour, if there are no inquiries, may I proceed with the first issue? Much obliged. Okay. The first issue is whether the plaintiff has asserted a justifiable cause of action and has successfully established a prima facie case. Generally, Order 14 of the Rules of Court 2012 enables a plaintiff to apply for summary judgment. Summary judgment may be sought in relation to the whole of claim of in arrears of summons or in relation to a part of the claim. So the plaintiff here filed this application under Order 14 Rule 1 of the Rules of Court 2012 on the ground that the defendant has no defense to a claim and that the statement of claim had been served on the defendant and the defendant has also entered an appearance in the action. Okay. For the guiding principle in an application for summary judgment, we can refer to the case of Shah Architect and another against Dinapuri Construction Sdn Berhad and others, 2021, MLJU, page 965, where the court stated that in an application for summary judgment under Order 14 of Rules of Court, the burden is on the plaintiff to establish the condition that firstly, the defendant has entered appearance. Secondly, the statement of claim had been served on the defendant. And lastly, the affidavit in support must comply with Rule 2 of Order 14, Rules of Court. Once those conditions are fulfilled, then the burden then shifts to the defendant to raise the tribal issue. So therefore, the plaintiff humbly submit that it is clear that the writ and statement of claim had been served on the defendant and that the defendant had entered appearance in this action. Thus, we are making an application for a summary judgment pursuant to Order 14, Rule 1 of the Rules of Court 2012. Therefore, from the above rule and order, we admit that the burden of proof lies on the plaintiff as the one applying for summary judgment. And to demonstrate that we have a prima facie case, we present to you the case of M. Berhad against Ref Engineering Worldwide M. Sdn Berhad and others, which in this case, the court was satisfied that the plaintiff had complied with all the preliminary requirements under the set where the defendant has entered appearance, statement of claim had been served on the defendant, the plaintiff affidavit had been complied with the requirement of Order 14. Therefore, as our client, the plaintiff, in accordance with the previous case I mentioned, has complied with all the set requirements under Order 14, Rules of Court 2012. We believe that our application for summary judgment should be allowed. Okay, regarding the aforementioned cases, it is evident since both the plaintiff and defendant had entered into a contract, the defendant's failure to make payment in accordance with the contract term constitute a breach of contract. Consequently, with the defendant made such breach, the plaintiff has a bona fide cause to sue the defendant. For the first issue, is there any clarification needed by the bench before I proceed with the second issue? Much obliged. Okay, moving on to the second issue, which is whether the defendant had breached the terms of contract when he agreed to take full responsibility for the reshipment of the timber but failed to do so. We humbly submit that the defendant had breached the terms of contract when they agreed to take full responsibility for the reshipment of the timber and also agreed to as well as all incidental expenses around in Singapore pending reshipment to aid it but failed to do so. In case of breach of contract, we refer to Section 75 of Contracts Act 1950, which stated when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled whether or not actual damage or loss is proved or to have been caused thereby to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, as the case may be, the penalty stipulated for. Other than that, we refer to the case of Fauzia Holding, Sdn Berhad against Metronet Corporation Sdn Berhad, which also referred to the previous section, Section 75 of Contracts Act. Breaker has refused to perform his obligation. Furthermore, in the case of Selva Kumar anak lelaki Purugiah against Tiaga Raja anak lelaki Nasami, this case also affirmed the principle that stipulated actual damages or reasonable compensation must be proved. Therefore, Your Honour, we submit that the plaintiff had already performed their obligation by making an advance payment of freight charges for 907,350 Singapore dollar as requested by the defendant, but the defendant failed to effect payment of the sum to the plaintiff as another amount of $60,000. Therefore, no, the plaintiff had agreed to bear on the agreement minute. Therefore, this portrays that the act of defendant failing to pay the balance sum of freight charges to the plaintiff can be considered as a breach of contract in this present situation. Okay. If there is no inquiries by Your Honour, that is all for the first and second issue.
Okay. Good morning. Very pleased to this honourable court. My name is Nur Anis Nadhira, the co-counsel, and I will continue submitting the next issue. Yang Arif, the last issue to be submitted to this court is whether the defendant has no tribal issue. Yang Arif, in order to show that the defendant has no tribal issue, we refer to the case of Shah Architect and another against Minapuri Construction Sdn Berhad. In this case, the court held that the Court of Appeal had put the burden on the plaintiff to close this case on Order 14 application. In application under Order 14, the burden lies on the defendant, which is firstly on the first condition, the defendant must have entered an appearance, and the statement of claim must have been served on the defendant, and the affidavit support must comply with Rule 2 Order 14 Rule of Court. So once those conditions are fulfilled, the burden then shifts to the defendant to raise the tribal issue. With regards to the above mentioned case, another case that should be highlighted is Salvadori against Chinia. In regard of evidential burden of proof, it's only shift to another party. Once the party was discharged of its burden of proof, plaintiff must prove on balance of probabilities. In this scenario, the other party need not to present evidence if the first party failed to prove in its case. The plaintiff need to establish his case, and if the plaintiff fails to, the plaintiff cannot say that the defendant did not establish their defense. In Bank Negara Malaysia against Muhammad Ismail and others, the court clearly stated that in a summary judgment application, the court must be satisfied that there is no tribal issue raised in the defense. Although a complete defense is not necessary, but there must be a tribal issue as limited. In relation to an application of summary judgment by the plaintiff, Tunas Gagas Sdn Berhad against Ramli bin Zahari further reiterated that the court must determine whether there are tribal issues which would defeat the plaintiff's assertion that the case is suitable for summary disposal. So it is very apparent that the court will only grant a motion for summary judgment in a straightforward case where the defendant cannot raise any tribal issues or circumstances that would require a trial. Therefore, damages Section 74 of Contract Act limits plaintiff claim for damages caused by breach of contract. There are two limbs under Section 74, subsection 1, and the compensation becomes payable to the injured party. The first limb is when the damages or loss caused by the injured party arose naturally in the usual course of thing from breach. This is normally referred to as the first limb and the term as general damages. And secondly, when the parties to the contract were fully aware at the time when they made the contract that damage or loss is likely to result from the breach of contract, this is referred as second limb and termed as special damages. Well, therefore, Ya Arif, we submit that the defendant has no tribal issue or defense due to the existence of two limbs under Section 74. That's all from.
Good morning, Arif. May it please this honourable court. My name is Nur Aina Azmeeza Azmi, the lead counsel on behalf of the defendant. Together with me is two of my learned co-counsels, Syafawatul Husna binti Ramli and Hayatul Husna binti Madihah. My lord, an application has been brought by the plaintiff to obtain summary judgment against the defendant under Order 14, Rule 1 of Rules of Court 2012, where the plaintiff had entered into an agreement in writing with the defendant, where the plaintiff agreed to buy and the defendant agreed to sell under the contract to sell timber to be shipped from various ports in Malaysia to Aden, and the terms of payment were 232 million per ton cost and freight. The defendant then shipped the timber on board the vessel Senang Island from Kuantan, whereas the plaintiff made the payment under the agreement. However, the vessel was arrested and the cargo timber was unloaded in Singapore while en route to Aden. The defendant wanted to take full responsibility for the timber, the freight charges, and the incidental expenses, and reship the timber by Kota Abadi to Aden. Yet, it should be noted that the plaintiff, who should be responsible for the reshipment of timber by another vessel named Kota Abadi, as the legal responsibility of defendant ceased when the sawn timber were loaded on the board the vessel Senang Island of Kuantan, and when it was the plaintiff who made the application to the Singapore High Court for the reshipment of the sawn timber to Aden. Furthermore, there was no consideration on behalf of the plaintiff, as the plaintiff should be responsible for the reshipment of the timber according to the cost and freight terms. Hence, my lord, in response to the plaintiff's submission, there are three issues to be submitted before this court, where the defendant contends that the summary judgment cannot be obtained by the plaintiff. First, whether the existence of tribal issues require a full trial. Second, whether the agreed minute relied on by the plaintiff is made without due consideration. And third, whether the legal responsibility of the defendant ceased when the sawn timber were loaded on board the vessel Senang Island at Kuantan under the cost and freight contract. I will be submitting the first issue, and my two co-counsel will submit the subsequent issues respectively. My lord, if there is no question, may I proceed to the first issue? Much obliged. My lord, for the first submission on whether the existence of tribal issue requires a full trial, we submit that there are some issues which need to be considered before the court decides on the summary judgment application. The issues can only be addressed at a trial with the supervision of the judicial investigation. We would like to highlight Order 14, Rule 1 of the Rule of Court 2012, which according to the rule, the case must go into a full trial if the defendant has a defense against the claims made by the plaintiff, whereby the application for a summary judgment made by the plaintiff will be rejected. This is justified if we refer to the decided case of Abdul Rahim bin Abdul Hamid and others, and Perdana Merchant Bankers Berhad and others, year 2000, Volume 2, Melayu Law Journal, page 417. It was stated that a summary judgment by a plaintiff should be rejected if the defendant is able to show that there is a tribal issue which requires a full trial. We also refer to the Supreme Court case of Gunung Bayu Sdn Bhd and Syarikat Pembinaan Perlis Sdn Bhd, year 1978, Volume 2, Melayu Law Journal, page 332. It was held that if there is an issue which led to a reasonable doubt that the plaintiff is entitled to a summary judgment, then it is a tried law that the leave to defend must be given. We also refer to the case of Southeast Asia Insurance Berhad and Kerajaan Malaysia, year 1996, Melayu Law Journal, unreported, page 642. It was contended by the court that it is a settled law that when a defendant succeeds in raising a tribal issue in an Order 14 application, an order for summary judgment is not fit and proper for such case, whereby only when there are no issues to be tried should the Order 14 to be succeeded. Then in Bank Negara Malaysia and Muhammad Ismail and others, year 1992, Volume 1, Current Law Journal, page 627, the Supreme Court held that the court must be satisfied that the defense has raised an issue that is tribal on the affidavit evidence in an application under Order 14. Then we also submit that the defendant does not have to fully establish our defense at this stage, as we are able to prove that there exist issues that are tribal and worthy of a full trial as required. This is evident by referring to several cases such as the case of Azlin bin Khalid and Muhammad Najib Ishaq and other appeals, year 2017, Volume 6, Melayu Law Journal, page 537. The Court of Appeal decided that it is well established from the principles to apply for summary judgment if the defendant raises one bona fide tribal issue in the affidavits that the defendant files. A full trial would be proceeded in the suit between both parties, in which the defendants need not to prove their defense and that the requirement needed to be fulfilled is raising a tribal issue. We also refer to the case of Wu Min and others and Leong Chun Fat, year 1982, Volume 2, Land Law Journal, page 241, the Federal Court mentioned that the respondent must not only raise an issue or any issue in answering the applicant's application for final judgment, but such issue raised must be an arguable issue that would require a trial to determine. Thus, my lord, for the first submission, we submit that the existence of tribal issue would require full trial and the summary judgment may not be obtained. These tribal issues would be raised by my other two co-counsels in their submissions. Having finished with the first submission, is there any clarification needed by the bench before my co-counsel continues submitting the next submission? Much obliged.
Good morning. May it please this court, my name is Syafawatul Husna binti Ramli and I will continue submitting the next issue. My lord, for the second issue, the defendant submits that the agreed minute relied on by the plaintiff is made without due consideration. My lord, in order to show that there is no consideration from the plaintiff to support the alleged agreement, we refer to the definition of consideration as provided under Section 2, subsection D of the Contracts Act 1950, as when at the desire of the promiser, the promised or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something such as or abstinence or promise is called a consideration for the promise. Moreover, Section 2, subsection E of the same Act has stated that every promise and every set of promises forming the consideration for each other is an agreement. Section 2, subsection H has further stated that an agreement enforceable by law is a contract. Based on all these provisions, consideration is a necessary element in order to form a valid contract in the eyes of the law. Any party to a contract can only enforce his or her right through a valid contract. To form a valid contract, there must be a consideration moving from both sides of the parties for the sake for an agreement. An agreement that was made without consideration is void, as stated in Section 26. Coming back to the second issue, there is no consideration contributed from both parties that can be seen from the alleged contract which the appellant had relied upon in his allegation, namely the agreed minute. Only the defendant has provided for consideration. In the agreed minute, the defendant only signed with the term in order to undertake full responsibility to reship the 6,049 tons of sawn timber from Singapore to Aden using another vessel, since the previous ship from Kuantan was arrested and unloaded in Singapore. The full responsibility also includes all the expenses involved the payment of the freight. Hence, there was no consideration moved from the plaintiff side towards the defendant, which led to the contract being made without due consideration. Consideration must move from both parties of a contract in order to form a valid and enforceable contract in law. Even though the plaintiff has advanced 907,350 at the request of the defendant, nevertheless, it was not regarded as a consideration in the eyes of the law, since it was not included in the contract. Thus, it was actually made outside the disputed contract. The agreed minute is void and remains as being made without due consideration. Thus, my lord will submit that the agreements made by the defendant, that the agreed minute which was relied upon the plaintiff was made without due consideration and renders the contract void, since the element of a valid contract was not fulfilled. Therefore, the alleged contract cannot be enforced by the plaintiff. So having finished with the second issue, is there any clarification needed by the bench before my co-counsel continues submitting the next issue? Much obliged.
Good morning. May it please this court. My name is Hayatul Husna binti Madin and I will continue submitting the third issue. Your Honor, the defendant would like to submit that under a CNF contract, the legal responsibility of the defendant ceased when the sawn timber was loaded on board the vessel Senang Island at Kuantan. As such, when the vessel Senang Island was arrested in Singapore, the plaintiff had applied to the Singapore High Court to offload the sawn timber so that they could be reshipped to Aden by another vessel. Furthermore, by making such an application, the plaintiff had exercised the right of ownership over the sawn timber of those that had passed or deemed to have passed to the plaintiff at the Kuantan shipment place. Therefore, when the defendant signed the agreed minutes to undertake full responsibility to reship the 6,049 tons of sawn timber in another vessel from Singapore to Aden at the respondent's own expense, there was no consideration to support the alleged payment. We refer to the case of Syros Shipping Co. and Illegal Trading Co. reported in 1981, All England Report, page 189. The ship owners chartered their vessel to the charterers who used it to carry a consignment of tractors from Sweden to Yemen. The freight was paid by the Yemeni consignees to the charterers, and a bill of lading signed by the master of the vessel and binding on the owners were issued to the consignees. During the voyage, the charterers became insolvent and defaulted on the payment of hire to the owners. Because of the congestion in the port in Yemen, the owners ordered the vessel to proceed to other ports to discharge the rest of her cargo. Before the vessel returned to Yemen port, the owners negotiated with the consignees for an extra payment for the discharge of the cargo free of any liens. The consignees agreed to pay an extra 31,000 US dollar over and above the freight already paid. However, when the cargo had been discharged, the consignees refused to pay the 31,000 US dollar. The dispute was referred to an arbitrator who held that there was no consideration for the agreement, but the consignees were nevertheless stopped from departing from the agreement. The arbitrator therefore upheld the owner's claim. The consignees applied to have the award set aside on the ground that it contained an error of law on its face. It was held by Lord Justice that the ship owners had no claim other than by virtue of the agreement for the 31,000 US dollar they were seeking to recover from the consignees, and in the absence of consideration, they could not enforce that agreement or rely on equitable estoppel as creating an independent cause of action. Therefore, when the plaintiff made an application to the Singapore High Court for the reshipment of the sawn timber, the legal responsibility of the defendant ceased when the sawn timber was loaded on board the vessel Senang Island at Kuantan, and concurrently, the agreed minutes made between the plaintiff and defendant was made without consideration. Based on the above claim, the defendant would like to submit that the plaintiff had not to make consideration for the part in the agreed minutes, and thus, the defendant is not responsible for the cost of the freight charges and the reshipment of the sawn timber by another vessel to Aden. Having finished with the third issue, is there any clarification needed by the bench? Much obliged.
Yang Arif, in this rebuttal session, we would like to rebut the argument from the defendant, which stated that there is no consideration contributed by both parties in the alleged contract, namely the agreed minutes. Therefore, we would like to submit that there is an existence of consideration in this contract. A consideration is defined by Section 2, subsection D of the Contract Act 1950 as when at desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or to abstain from doing something such act or abstinence or promise is called as consideration for the promise. In Wong Hon Leong David against Nur Azman bin Adnan, 1995, the appellant promised to pay respondent RM 260,000 in return for the respondent application to convert and subdivide certain land to be developed into a housing estate. The court held that the exchange of mutual promise, though it is an executory consideration, was a good consideration, therefore was a binding contract. Furthermore, in K. Murgesu against Nadaraja, the appellant agreed to sell a house to respondent for $26,000. The respondent obtained an order for specific performance. On appeal, counsel for the appellant submitted that there was no consideration for offer to sell and the agreement was therefore void. However, the Federal Court dismissed the appeal and the agreement must be seen to be case of executory of consideration. In agreed minutes, it had been mentioned that the defendant itself had undertaken to take full responsibility for the reshipment and had signed the said agreed minutes, but they decided to waive on the said agreed minutes. Therefore, the plaintiff also had advanced the payment for reshipment as requested by the defendant. Therefore, Yang Arif, we would like to submit that due to the above mentioned reason, had portrayed that there is an act of consideration existed in this contract. Having finished with my rebuttal session, move on to the rebuttal session for the defendant.
Your Honour, the defendant has a point to be has a point to make regarding the plaintiff's rebuttal. The plaintiff contended that consideration does exist between plaintiff and defendant in the agreed minute when the defendant undertook full responsibility for the shipment of some timber. Yet they argue that defendant had waived the consideration. However, at the material time, when the defendant offered to take full responsibility for the shipment of the sawn timber, the ownership of the sawn timber on board already shifts upon the plaintiff. This is further justified when the plaintiff had clearly exercised his right of ownership when they applied to the Singapore High Court to offload the sawn timber so it could be reshipped. In order for the consideration to be valid, there must be a bargain for exchange in an agreement. This means that both parties must be getting something that they have both agreed to. Normally, it consists of something of value or for something of value. Nevertheless, since the defendant had no longer the right of the ownership over the sawn timber due to the plaintiff's action, hence the defendant does not give or offer something that is of value that can be considered as valid consideration. Therefore, there is no existence of consideration moving from both plaintiff and the defendant in the agreed minute. Your Honour, that should conclude my rebuttal. Much obliged, and may it please this Honourable Court.
So with the permission of Yang Arif, may I conclude the oral submission? So based on the above mentioned agreement on behalf of the plaintiff, to ask for this honourable court to consider our submission and to grant the plaintiff order 14 application for summary judgment expedient and submitted. And we also pray for any other relief or order that deems suitable by this honourable court. We humbly submit that firstly, the plaintiff has shown a complete cause of action. Secondly, the act of the defendant failed to pay the balance sum of 5 charges to the plaintiff constituted as breach of contract. And lastly, the defendant has failed to raise any tribal issue, and such the plaintiff has established a prima facie case against the defendant and shall be remedied without any delay. So if I am of no further assistance to this court, that should conclude our submission. Thank you for your time and indulgence, Your Honour.
May it please this Honourable Court, my Lord. For the conclusion, the defendant submitted there is an issue to be tried or disposed of in the case before the court which needs to be resolved by a full trial rather than the application of summary judgment, as this will jeopardize the defendant's right to defense in this case. So in this premise, the defendant respectfully prays for the plaintiff's claim to be dismissed with cause. And if I am no further assistant to this court, this shall conclude my submission. Thank you for your time and indulgence, Your Honour.